Hello, my name is Lilibet Musime. I am taking you through law of contract. I'm an assistant lecturer at Kabale University. So today we're going to be looking at law of contract, and specifically, this will be an introduction into the vitiating factors. So number one, as you'll notice, the first part of contract normally is the study of the basic constituents of a contract, and these are offer, acceptance, consideration, contractual capacity, intention to create legal relations, and also a union of minds, which is union of minds of the parties, which is basically consensus ad idem. So what the first part of contract basically did was take you through these basic constituents, give you the rules of acceptance, the rules of offer, and the rules of consideration, what consideration is and what consideration isn't. Now, this particular class, the aim of this class is to give you an introduction into the matters that affect validity or enforceability, discharge of a contract, and also the remedies of a breach of contract. Now, discharge of a contract basically looks at all the parties of the contract performing their rights and obligations within that contract. Now, the breach of a contract normally happens when a party or one of the parties does not meet the requirements in that contract. So, but for this particular class, all we are going to be looking at is the matters that affect the validity of a contract. So, while a contract is concluded with all the elements of a contract, and that makes it valid, there are situations that arise that may destroy the basis upon which this contract or this agreement was reached, so that the contract is discharged or in some way vitiated. So the first question that should be going through your minds right now is, what is the definition of vitiate? The Cambridge Dictionary defines vitiate as to destroy or to damage something. So this contract may be valid because it has all the elements, that is offer, acceptance, consideration, and all the rest. It may be valid in that sense, but there is something, or there is a factor, or there is an element that will destroy or damage it. So, where an act or an omission has the effect of affecting the ability of the parties to freely consent to a contract, it is known as a vitiating factor or element. So, these vitiating factors normally affect the ability of parties to freely consent to be in that contract. So, Section 13 of the Contracts Act of 2010 provides for free consent of parties to enter into a contract. However, it says that this consent will not be free if it's caused by coercion, undue influence, fraud, misrepresentation, or mistake. So, right off the bat, these coercion, undue influence, fraud, misrepresentation, and mistake are known as the vitiating factors. So in this particular class, we will go through each and every single one of those vitiating factors. However, today we will look at mistake and give you an introduction into mistake before we delve further into it. So under Section 16(1) of the Contracts Act, where consent to an agreement is obtained by coercion, undue influence, fraud, misrepresentation, the agreement is voidable. That means it is up to the option of the innocent party either to remain in that contract or to repudiate it, to either ratify that contract or to repudiate it. So this agreement is voidable where consent is obtained by coercion, undue influence, fraud, or misrepresentation. So right off the bat, it shows you exactly what amounts to or what would make the contract voidable, which is coercion, undue influence, fraud, or misrepresentation. Now today, we'll be looking at one of these vitiating elements, which is mistake. So the definition of mistake, mistake may be defined as an erroneous belief concerning something. It may also be defined as a misapprehension or misunderstanding of the state of affairs relating to the substance of the contract, substance or subject matter. So it is and misapprehension or a misunderstanding or an erroneous belief concerning something. So in this sense, it would be an erroneous belief concerning a contract. So basically, a contract, as has already been mentioned, a contract thrives on the mutual consent of the parties, which is consensus ad idem. So if there is an absence of this mutual consent of the parties on account of a mistake, whether by one party or both parties, this vitiates the contract. So the effect of the mistake on the validity depends on the type or nature of mistake made. So in general, the contract entered into or induced by a mistake can be void or voidable. So the only way you can find whether this contract is void or voidable, first of all, it depends on the mistake, and it also depends on what the law says about that particular mistake. For example, Section 18 of the Contracts Act of 2010 provides that where a contract is entered into by mistake in respect of any law in force in Uganda, that contract is void. For example, if the contract is for supply of goods from Kenya, and at that time it has been the exportation or the importation of goods from Kenya is looked at as illegal, then that would mean that particular contract for the supply of maize or supply of goods from Kenya is void as per Section 18 of the Contracts Act of 2010. So the next thing you should pay attention to, number one, is that not every mistake will have the effect of invalidating the contract. It must be an operative mistake. It must relate to the fundamental fact that existed at the time of making the contract. So in other words, the mistake must be one that affects a fundamental fact that existed at the time of making the contract. So it's not every mistake that will affect a contract. So the law recognizes 3 types of mistakes. Number one, a common mistake. This is where both parties make or operate under the same mistake, which is both the parties or more parties are all under the same misapprehension. They all have the same erroneous belief. That is what common mistake applies to. There are 2 kinds of common mistake, and these kinds of common mistake we will delve into and examine to find out what they are. Number 2 is mutual mistake, where the parties are at cross purposes with regards to the contract. And then number 3 is unilateral mistake, where one party to the contract is mistaken with regards to the contract. So all these types of mistakes we will look into. We will examine and see what the law says about this particular mistake. So that being said, this was just an overview of what you should expect in this particular class and what we will look into, that is vitiating factors and also how contracts are discharged. And if they are discharged, what are the remedies to the parties? If we go back, what are the remedies to the parties if there is a breach of contract? Thank you very much for your time. Thank you.